Hi guys, so in this video I'll be talking to you about land titles in Nigeria. So the first thing you need to know is that all the lands in the state are under the control of the governor of that state, and that is from the Land Use Act of 1978. This now puts lands in the state under two broad categories: freehold and leasehold. Lands that are freehold are lands that people are free to use, and leasehold is the opposite of freehold. People are not free to use these lands as they please. They need to go through the government before they can have access to these lands. And this comes in two categories. The first is the non-committed or global acquisition and committed acquisition. For lands that are under committed acquisition, these are lands that are intended for public use, which could be building schools, railways, and so on. Buying lands in these areas automatically means you are putting yourself at risk, because the government can come tomorrow, next tomorrow, 10 years, 20 years from now to come and demolish the houses on those lands, because those lands already have intended public use. In fact, all lands in the state are already charted. They already know those lands that are under government acquisition and those lands that are not. They already know what they want to use those lands to do. So before you buy any land, actually you should have your surveyor go to the land, mark the coordinates of that land, then go to the land registry to check the status of that land, whether it is under government acquisition or not, to be on the safe side. What is excision? You have probably heard about excision, land excision. So what is excision? Excision is simply the process of the government giving back a portion of land to the community. For instance, a government took 200 acres from a particular community and decided to give back 100 acres to the community. The process of the government giving back that 100 acres back to the community is called excision. And this excision could actually occur in different stages. First, the excision will be in process. Then second, the excision will be approved. Then third, it will be published in the journal called the Gazette. And that is how we have the gazetted excision. At what stage is a land under excision safe to buy? You can be 100% secure when that land has been gazetted. But while the land is still in excision in view or excision in process, I would not advise that you go for that kind of land. However, developers know what they can do to actually ensure that they still have access to that land. And one of the things they can do is called land regularization or land ratification. What is land regularization or land ratification? Let me use a simple example. An individual bought a land from a community, but unknown to them, the community did not tell them that that land is actually under government acquisition. They just sold the land to them so that they can get their money. Now, what do you do when you realize this? You go to the government and let them know that you've bought this land, but you realize it's under government acquisition. What can you do? If that land is under non-committed government acquisition, meaning there's no intended public use for that land, the government can decide to do a land regularization for you, so you can have access to that land, whereby they will allocate that land to you. You can use the land to do what you want to do. So that is one thing that you can do to save your land. But all of this actually cost you more money. And one reason for this is that there is actually some level of administrative bottleneck involved in land documentation in Nigeria that is not so easy to verify the status of lands. So at every stage, you want to make sure that you are doing your due diligence before you go ahead to purchase any land. The certificate of occupancy, this is the most common title that many people know of, and it's a document that is given to the first person that buys the land when the land was still virgin and only lasts for 99 years. Subsequent buyers are not going to get a new C of O, but rather there's going to be a transfer of that particular C of O from the first buyer to the next buyer, and so on. After 99 years, they will need to renew that C of O again. As the name goes, it's called a certificate of occupancy, not certificate of ownership. You are like a tenant to the governor, who is the landlord. You're only having access to that land for 99 years, and that is the certificate of occupancy. The next one to talk about is governor's consent. At every instance where there's an exchange of land or property from one person to another, there needs to be a governor's consent involved. But many times, because of the long processes that may be involved to go through that stress of getting a governor's consent, but as much as you can, please make sure you do the right thing. Go for your land documentation, even if it's going to cost you money. It is better you get the right documents for your land so you don't have troubles to face tomorrow. There are other documents that are also involved in the process of buying land, but they are not land titles, just for you to know. The first is the deed of assignment or deed of agreement. Deed of assignment, deed of agreement is a document that transfers the rights, the titles, and the ownership of that land from the seller to the buyer. It also shows the history of transfer of ownership of that land from the original owners down to the subsequent buyers till it eventually got to you, and it's a legally binding document. After buying a piece of land or a piece of property, there are certain documents that you must make sure you have in addition to the titles of that land. The first is your acknowledgement receipt, your contract of sale, your deed of assignment or deed of agreement, and also your survey. If you are dealing with real estate companies, they'll usually provide all these documents to you, but you should also make sure you do your due diligence. Get your own lawyer involved to draft up your deed of assignment or your deed of agreement, and then also get your surveyor involved when it comes to the registered survey. There are special cases that you also need to know about. One is the Supreme Court's judgment. For Supreme Court judgment, usually when there has been a dispute on a particular land and has been addressed in the court of law, they will give the Supreme Court judgment over that land, which will be the new title for that land. And whoever has that Supreme Court judgment will be the new owner of that land. So that's for the Supreme Court judgment. How do you claim ownership of a land that was willed to you? You go to the probate registry and get a grant of probate for you to be able to lay claim or ownership to that land. What if there was no will on that land? What you do is to get a letter of administration. What if your parents did not leave any will regarding their properties to you? What you do is to get a letter of administration from the Supreme Court that will give you rights and ownership to the property.